We've got new CCW regulations aimed to prohibit tons of people from getting CCWs. We've got more CCW regulations that look to correct the law because of a pro-2-way decision in the CRPA versus LASD lawsuit. And you've got that pesky 3-gun-a-month rule. All of this now signed into law in one bill by Gavin Newsom. That is AB 1078. Let's talk about it. Hey everybody, welcome back to the channel today. We are still on the path of understanding and looking forward to new laws that were signed by Governor Gavin Newsom and brought forth by the legislature that are anti-Second Amendment. If you hadn't seen it, last week we did Assembly Bill 1263 as well as Senate Bill 704. Today I wanted to cover Assembly Bill 1078. It kind of deserves its own video because if you're looking at some of these bills as they try to tackle an individual topic, this one kind of has three. So to walk us through that today, we have brought back the volunteer president of CRPA, that is Chuck Michel. Chuck, thanks for being with us today.
Always a pleasure, guys. Thanks for having me.
Absolutely. And guys, please, as always, be sure to like, share, and subscribe to the videos. We're trying to grow the platform so that we can get the message out to as many people as possible. By liking, sharing, and subscribing, it really helps. And hey, if you're already subscribed and you're not seeing us in your feed, YouTube kind of has a knack for turning off those notifications. So be sure to check on that. Turn on the notifications if they got turned off on you. We're trying to get these videos out as far as we can, and every view counts. So Chuck, let's just go ahead and dive on into this. As I kind of already alluded to, there's three really big things that I see with Assembly Bill 1078, which Gavin Newsom did sign into law. Looks like it's going to be taking effect this year. Jacob, if you could pull it up, let's tackle the restraining orders. So it reads like this. This bill would also prohibit a licensing authority from issuing a license if an applicant was convicted of, under any federal law or law of any other state that includes comparable elements of contempt of court or specified criminal statutes in the 10 years prior to the completed application, was subject to any restraining order, protective order, or other type of court order, or is an unlawful user of, addicted to any controlled substance as specified. Upon determining an applicant is a disqualified person due to being an unlawful user of or addicted to any controlled substance, this bill would require the licensing authority to, within 5 days, submit to a national instant criminal background check system index specified information of the disqualified person and supporting documentation as specified. This bill would require the review of the California Restraining Order protective order system to include information concerning whether an applicant is reasonably likely to be a danger to themselves, others, or the community at large as specified. By imposing new duties on local licensing authorities, of course, this bill would create a state-mandated local program. $, guys. I think that even comes up a few times in this bill. The bill would additionally exempt from the licensure prohibition of applicants previously subject to restraining orders, protective orders, or other type of court orders, applicants who were previously subject to an above-described order that did not receive notice and an opportunity to be heard before the order was issued. This bill would revoke or prohibit the issuance of that license by any local licensing authority if any certain situation occurred, including that an applicant knowingly provides any inaccurate or incomplete information in connection with the application or a license renewal, or an amendment to the license. The bill would require a licensee to inform the local authority that issued the license of any restraining order or arrest, charge, or conviction or of a specified crime, and would prohibit the issuance of or require the revocation of that license based on the licensee's failure to inform the local licensing authority of any restraining order or arrest, charge, or conviction of a specified crime. Thank you very much for going through that with me. I know that it was a lot to read. I promise that's the longest one that we'll read today. However, there are two kind of glaring things that pop out at me when it comes to the denial of a CCW application or the revocation of a CCW application. The first one starts with restraining orders. And Chuck, I know we've done a lot of talking on restraining orders about the lack of due process that really is foundational within the process of restraining orders at times. It says that an application that'll be revoked if it's found that a restraining order exists, except it then follows up and says, except for those who haven't been heard by the court and haven't been notified that they're subject to a restraining order. I guess I'm just kind of curious, is this still kind of missing the mark, or is this closing the loop on lack of due process when it comes to restraining orders for those who are applying for CCWs?
Well, it's a mixed bag. And as you can see by just how much trouble you had trying to read it, there's a lot to it. Generally speaking, restraining orders, whether it's a domestic violence restraining order or a GVRO or just a TRO, they've been problematic for years because there has not been due process. Every lawyer who practices family law and divorce knows that you can gain a strategic advantage by having a woman claim that the person that she's trying to get divorced from, was somehow committed domestic violence. And if they get a restraining order, often the person that they're trying to get that restraining order against doesn't even get notice. So that's been a huge problem. So to the extent that this new statute prohibits the state from disqualifying you from getting a CCW because a restraining order was issued that you never got notice of or had no opportunity to be heard and contest it. Because a lot of times, if you go in and contest it, unfortunately, it costs money, but you can beat them. So they're trying to walk the Rahimi line here. The Rahimi case from the Supreme Court said that you can't disqualify people basically on innuendo. There has to be that due process. So to the extent that this creates due process for people who are accused but not found liable for some kind of incident that would justify a restraining order, it's good. But it also creates a whole bunch more red tape and a whole bunch more ways that an issuing authority can abuse their discretion and use things as an excuse to deny or revoke a license. So there's going to be a lot of contests. We're still looking at this on whether or not there's a global challenge that we could make to some of these laws. We're looking at the entire CCW process, though. Character references, psych review, out-of-state recognition, the cost, the training requirement, the 2-year limitation, all that stuff. This just adds to the morass of red tape that you have to go through. In this case, it's only if you've gotten in trouble with a restraining order or a contempt of court proceeding. So it's not that many people, but it's still not good. It still complicates the system. It's still a justification for delay in some cases. So, and they could simplify all this by just requiring people who have a CCW to also get a certificate of eligibility, because if you get convicted of something or a restraining order that prohibits you from possessing a firearm, the COE picks up on that and could give notice to the local issuing authority that you're no longer legally permitted to own a gun, and your CCW would be revoked. It's a very simple process, but they got to complicate it because they want to red tape this right to death.
Yeah, it seems like they definitely want to catch people when they don't deserve to be caught. And this really it ends up being applied to some people that we've talked to. I remember having an individual on the channel who got into a dispute with their neighbor, and restraining orders ended up being applied to both. And that video was about how it was a travesty that she had her firearms taken away from her, but
we've handled multiple cases that are those kinds of examples. One where we had neighbors where the woman neighbor was crazy and was throwing trash over a fence onto our client's property and screaming at him. And they put cameras up to catch this. And then we used the film from the camera to get a restraining order against her. But then she got a restraining order for the cameras. Now, it's fine. You want to say we can't point the cameras on your property? Great. But that TRO triggered a firearm prohibition. So the firearm prohibition was because they had cameras that bled over a little onto the neighbor's property. The system is ripe for abuse and has been abused for years. This may make it a little better, but it's also going to be more things that we have to fight for people.
the way that this reads, it seems like for the next 10 years, because of that restraining order, she wouldn't be able to apply for a CCW if she wanted to.
And
So
that period there is not going to, that can't stand. 10 years is baloney. So
yeah,
we'll be challenging this, whether it's through individuals, probably has to be through individuals who have faced this situation, as opposed to a facial challenge to the entire law. But one way or another, this is going to have to be challenged.
well, let's look at another element of what we've just read here. And I'm curious, as somebody who's been practicing law for as long as you have, how do you prove that somebody knows something? Because it seems like what this law is stating, that if you knowingly omit information on your CCW application, you are automatically disqualified. And, I guess in some senses, it seems like it's logical, but when you're talking about going back 10 years, like I'll divulge a little bit. When I first applied for my CCW, I forgot a couple of parking tickets. I didn't put that on my form. Now, fortunately, I'm in a nice area where they want good people to have CCWs. We talked through it, and that is what it is. But if you want to consider that, something that is against the law, people are going to be automatically disqualified for potentially just forgetting something on their CCW application.
Right.
How does
like a speeding ticket 9 years ago that you went to traffic school for? You know what I mean?
Right. So how does that, how does that affect things when you're talking about potentially challenging something like this? I mean, how do you prove that somebody knows or doesn't know that?
They'll say, you were issued a ticket, you signed the ticket, or you got a notice in the mail. But a knowing violation is always an issue in any kind of criminal prosecution, where you have to have a knowing violation or a willful violation. That's always a factual issue that gets disputed. So when they try and pull a license from someone for knowingly failing to disclose something, there will be administrative reviews going on in each of these departments, and some of the departments won't care. So Orange County, Riverside, they're not going to think that you're a bad person because you got a speeding ticket or a parking ticket. But in other cases, other jurisdictions, maybe like LAPD or LA Sheriff, they'll use that as an excuse, and then we'll have to fight it.
It does. It does seem like they are kind of propping up the ability for license issuers to kind of have an excuse to disqualify people from CCWs. Definitely want to keep an eye on this portion of that law moving forward. I did want, and guys, like as far as two-way laws are concerned, this is probably the closest you're going to get to like an omnibus bill. You got several things in this bill. So Jacob, if you could pull this one up, we're kind of moving into new territory, but this is the same bill, AB 1078, and it reads like this. Existing law prohibits a person who is licensed to carry a firearm from carrying a firearm in specified places, including schools, government buildings, hospitals, zoos, parks, churches, and a bus, train, or other forms of public transportation. Existing law exempts a firearm that is secured in a lockbox as specified under certain circumstances from these prohibitions. This bill would exempt a firearm that is unloaded and locked in a lockbox for the purpose of public transportation or for the purpose of transporting the firearm from the prohibition on carrying the firearm on a bus, train, or other form of public transportation, including building, real property, or parking area under control of the Public Transportation Authority. This bill would clarify that the requirements for a new license or license renewal specifically apply to California residents. For non-California residents, the bill would additionally require, among other requirements, the applicant to attest under oath that the jurisdiction in which the applicant is applied is the primary location in California in which they intend to travel or spend time, and that the applicant has completed a live-fire shooting exercise for each pistol, revolver, or other firearm for which the applicant is applying to be licensed to carry in California. By requiring local agencies to issue licenses for concealed carry to non-California residents, residents and expanding the scope of the crime of perjury. This bill would create a state-mandated local program, $sign. Told you guys it was in more parts of this bill. This bill would also authorize the licensing authority to allow non-California resident application to satisfy the psychological assessment with a virtual psychological assessment as specified, or approve this examination with a provider located within 75 miles of the application's residence. This seems like they're trying to clarify some things. Is this the legislature taking note from the CRPA versus LASD lawsuit?
Yes, this mirrors the injunction that we got from the judge in the Los Angeles County Sheriff case, so that out-of-state residents can get a California CCW. And now we have to look at it and compare it to the requirements that they're putting in place for in-state residents, because in some ways it's actually easier to do an online psych review or online. And by the way, psych review is not mandatory every single time. Some jurisdictions make every applicant go through this psych exam, which is pretty much baloney. They're not really able to detect anything from a 20-minute interview or a questionnaire. But a lot of this can be done online now for out-of-state applicants, and it should be the same way for in-state applicants. Speed up the process.
Can you actually expand on this? We're suing Santa Clara County over the psychological testing. I mean, as well as the high fees, but focusing on the psychological testing, this seems like a direct response from Bruen that a lot of these issuing agencies have really taken. But I mean, in its truest form, is psychological testing a tool that was to be used, or is it abusive? I mean, how was psychological testing?
Look, this is the naked man problem. This is the famous line from Clint Eastwood: "When I see a naked guy chasing a woman down the street with a butcher knife and an erection, I shoot the bastard." I mean, when you have somebody who's truly showing signs of mental illness, that's when the background check should be able to include a psych exam. And for that matter, a character reference. You shouldn't have mandatory character references in every case. All of that is things that police departments are used to doing when they're looking into someone's background. So it's a tool that they can use when they're doing a background check, but it shouldn't be mandatory every time. That's just a way to cost more and take longer to process an application. So when you have someone who's showing signs of mental illness, you dig a little deeper. But not every person comes in there, showing signs of mental illness. So there's no reason to go through all these hoops and all the expense and all the time just to approve the license.
And I know that this is just kind of touching on a part, but could you explain the process as it's kind of been laid out since we got our decision in our lawsuit against the LA County Sheriff's Department? What is the process that somebody from out of state goes through to get a CCW in California now?
Well, depending on where they're thinking they're going to visit, and that's a whole vague, dumb, I mean, what does that mean? You drive in and you come through Riverside and you spend the night in a Holiday Inn, and then you can attest that you were spent your primary place to visit was Riverside, and then you go to San Diego and you stay a couple more days. I mean, who knows? Nobody comes in and just, well, I guess some people do come in and just visit one place, and then that's where you could apply for a CCW. Conceivably, any place that you spent some time, if you were on a trip and you go to San Francisco and you drive the coast and you go to Disneyland and you go to San Diego. I mean, all of those places are potentially places where you could apply. So what's probably going to happen is people are going to come visit the places where the licenses are processed, out-of-state license applications are processed quickly, and then they can honestly say, this is where I spent most of my time or plan to spend most of my time, so I can apply here. But so you apply from out of state, and then each department has slightly different setups for all applicants, not just out-of-state applicants. So you're going to look, basically your people are going to be shopping what jurisdiction they're going to come spend time in to justify getting a license from there.
This is kind of why I ask, because even the way that you're describing it, it seems like it's still a little bit ambiguous. Does this get flushed out with further work from the legislature or through the court systems?
Probably both. I mean, the legislature doesn't seem inclined to really fix stuff unless there's a court order, because that's why we got most of this stuff, is because of Rahimi from the Supreme Court and because of the injunction that we got from the district court, federal district court in the LA County Sheriff lawsuit. So look, we're going to have to, the issues in the lawsuits are going to get finer and finer and finer. And because, everything's sexy about semi-auto bans and magazine bans and the whole good cause issue, but CCW is becoming really specific in all the little details that they're trying to put in place to get a license or not get a license. So there's going to have to be issues that get smaller and smaller. We're looking at challenging, though, the entire CCW statute. And in fact, we're working with the U.S. Federal government, the Civil Rights Division, to look into that kind of a challenge, because we have to keep playing whack-a-mole. This district charges too much, this district takes too long. We have to sue each of them. We need to take, when it comes to charging too much, if the jurisdictions are allowed to recover their actual costs, that just encourages them to be inefficient. That means they want to hire on-duty union members that have to be paid overtime to process CCW applications, so it costs 5 times as much as a retired deputy getting paid by the hour who's on his pension. Well, it's the games that are being played at CCW, which are going to keep us busy for a while as we keep fighting all of their efforts to water down Bruen. Now, we may get some help from the Supreme Court. They have taken a case on sensitive places. And no matter what case they take, it's the methodology, the games that the state attorney generals like California are playing is they're saying, magazines aren't an arm, and there's no Second Amendment right in sensitive places at all. You don't even need to look for any kind of historical law that would justify a modern day law. So the Supreme Court could clarify some of this in the Walford case that it's taken right now. But there's also a number of other cases that are pending in the Supreme Court, most notably our Duncan case. And hats off to the NRA for helping to finance that case. But the Supreme Court's got to take it for us to benefit from some more Supreme Court guidance, or one of the other cases. So we're all really waiting for that next Supreme Court case to clarify what states can and can't do when it comes to restricting your rights.
Well, definitely looking forward to that. Going to be checking every Monday to see that order list that the Supreme Court comes out with, to see if they take that case. And really, it seems like more to look forward to as far as the way that this develops, the out-of-state CCW thing, as well as some of the sensitive places things. Let's move on. This is the last part, and this is really the part of 1078 that we were shouting loudest about. Jacob, if you could pull this up. Guys, I promise this is just a small paragraph. It's the last thing I'm going to read today. It reads like this. This bill would, beginning April 1st, 2026, increase the number of firearms that a person can apply to purchase within any 30-day period from 1 to 3, and would prohibit, beginning April 1st, 2026, delivery of a firearm by a dealer if the dealer is notified by the Department of Justice that the purchaser has made an application to purchase one or more firearms that would result in the purchase of more than 3 firearms cumulatively within a 30-day period preceding the date of the application as specified. The bill would make a conforming change to the requirements to the required firearm safety warning. So this is the 3 guns a month rule, and I mean, I don't know how we look at laws that are written incorrectly, because by April 1st, 2026, it's going to be a decrease to be able to purchase 3 guns a month, not an increase, because of the Nguyen v. Bonta lawsuit, which is kind of where I want to start with you on this, Chuck. Can you go ahead and give us just a really quick review on Nguyen v. Bonta for those who haven't seen the videos about it earlier this year and what we got from it?
Yeah, that's the lawsuit that challenged 1 gun a month. That was brought primarily by Second Amendment Foundation and Firearms Policy Coalition. And that was a great win because they did not get en banc review. So the 3-judge panel win became final. That's the law of the land. So naturally, the legislature can't let that happen. So they go and say, well, okay, if we can't limit you to 1 gun a month, then we're going to limit you to 3 guns a month. This is absolutely going to be challenged. There was nothing in the 1 gun a month decision striking down the 1 gun a month law. that said anything about you could just bump it up a little bit and rationing would be okay. And it certainly wouldn't be three. So there'll be another lawsuit, and we'll help whoever the plaintiffs are in that lawsuit, which we may join. I'm talking to the folks about that now at the other associations to strike down the 3 gun a month. So it's a chronic cat and mouse game that a constant cat and mouse game that the legislature likes to play. By the way, being coached by Everytown Law and billionaire Michael Bloomberg's millions and millions of dollars. That's what we're up against. Millions of dollars spent on lawyers for Bloomberg, who then coach the lawyers for the different anti-gun owner states, who then spend taxpayer dollars to try and push these laws and then defend them in court while we're trying to, raise money from our members to to strike them down. So every time we win a case, that's just a way for us to file another case. Every time we meet a goal, we just look at it's a target-rich environment, so to speak, for challenging California's gun laws. As I've said before, my gun law book right now is about 600 pages long. I can't wait till it's a little brochure that has a couple of pages to it, because right now there's like 800 gun control laws in California, most of which do nothing to keep us safe. If they target violent criminals, that's one thing. But if they're just targeting guns and turning people into criminals because they don't understand, the law is very complicated. Obviously, that's why you need a 600-page book. Innocent people, good people just get in trouble because the law is so complicated.
Well, I'm sort of curious, at what point do you have enough precedent for these things to not take time and effort? I mean, this Nguyen lawsuit, literally just happened this year. It said you can't put any limitations on it. How far and how narrow does this challenge need to be? We have the precedent from the Ninth Circuit already. Will it be quick through the courts, or will it be?
It should be. I mean, they should be able to go in and do a facial challenge and say, here's the Nguyen decision. This three guns a month is no better. It should be quick, but the state always tries to slow things down. And you can't go for a preliminary injunction the same way you used to, because if you go for a preliminary injunction and then the state revises the law, and they know how to play this game, they try and revise the law to moot your injunction, and then it deprives you of the ability to recover attorney's fees as the prevailing party. So this is another game we have to play, but we can't always go in as quickly as we would have done before. And that's not, by the way, just Second Amendment litigation. That's civil rights litigation in any context. ACLU is complaining about that. But still, the 3 gun a month should be a fairly simple challenge that just relies on the 1 gun a month decision, the Nguyen decision, to strike down 3 gun a month.
Absolutely, we will, but looking forward to that lawsuit, and hopefully it is a quick one. I mean, you got really 3 large elements in this bill 1078. I guess as an overview, Chuck, how does this work? When you're talking about a bill, when it's going through the legislative process, you can either pass it, you can kill it, or you can amend it to be passed a different way. Does litigation work the same way? Can you parcel these pieces out for separate lawsuits? Does it become one big lawsuit?
You usually want to, because there are page limitations on briefs that you can file. So you don't want to overcomplicate a case. You can take a statute and break it down to its component parts. The statute may be one bill. Excuse me, I'm using the word, I'm being imprecise here. The bill may modify more than one statute, one law, specific code section. You're challenging the modification to the code section. You're not really challenging the bill as a whole. So whatever the bill does, if it modifies 10 different code sections, you could have 10 different lawsuits challenging the modification to each code section.
Well, we're going to be working on these, I'm sure, plenty of videos to follow. How do you see some of this litigation? You got to think the low-hanging fruit is the 3 gun a month rule. How do you see that working rolling into 2026?
Well, there's also the barrel background check, which is essentially the same as an ammunition background check, which CRPA is already putting together a lawsuit to challenge that one, because we won on Rhodey on the ammunition background check requirements. And so it should be the same, basically the same analysis. You can't set up this uh, cumbersome background check requirement just to buy a gun part, because that's what they'll do next. It'll be any part to a gun. You got to go through a background check. So right now it's barrels, but they'll expand it. So we're looking at challenging that. But ultimately, again, it's the Supreme Court that's got to basically slap some of these lower courts down and say you're not playing fair. You're not applying what we said correctly. You have to do it right. And once they start forcing the lower courts to do it right, we'll start turning laws over a lot faster and with a lot less delay and appeals and en banc appeals and all the things that they do to slow things down.
Yeah, I guess that makes sense logically. They continue to layer on anti-2A law after anti-2A law, and as we continue to challenge it, we end up laying on precedent and more precedent and more precedent. Hopefully, some of these lawsuits in the future can take less time because of that precedent that's been built. Chuck, final thoughts, and I want to thank you for coming on today.
Everybody, if you want us to continue fighting for your Second Amendment freedoms, we give generous. Our law firm charges greatly reduced nonprofit rates, and we watch the CRPA watches the money very carefully. I'm not paid for my services as president because I'm an activist, not just an advocate. And so the money is well spent. Every dollar you send in is carefully shepherded by our finance committee and our board of directors. So if you can help support the cause, you're part of history. This is a historic time for the Second Amendment. Be a part of history by giving whatever you can to support our efforts, and we'll keep fighting for you.
Absolutely. But thank you very much for coming on and taking the time. I know you're a busy guy.
Thanks, guys.
Absolutely. And guys, if you like this content, you want to continue to see that, you want to be someone who directly contributes to some of this litigation moving forward, please, you can do that by liking, sharing, and subscribing to the videos. It really helps get the information out there. Thanks again, guys. We'll see you on the next one.